Okay, first of all, when we talk about using entities and we're talking about loans with the banks and what they'll say, for the most part, we might have to ask the question, well, what kind of a property is it? But let's just summarize and say, we assume that a piece of property, such as real estate, has a mortgage on it. The bank holder is, of course, the person who has the first position interest on the loan. What most often we need to realize that there is great value in doing estate planning, and banks understand that. They just want to make sure that you're not using some strategy to be able to sell the property to someone else and they're going to assume your loan. That is, we haven't had assumable loans for many, many years. So if the bank smells like that, feels like you're maybe doing that, they could actually call the loan, which would be a disaster for you. So it's not a bad idea just to inform the bank. Say, I'm doing some estate planning and I'm trying to be able to put my real estate into an entity such as an LLC or limited partnership, and they shouldn't have a problem with that. They'll give you a little piece of paper showing their permission. Now, once in a blue moon, if you really get a bank that's kind of strict about that and they just don't understand it or they just want to deal with it, they'll tell you that you can't do that. But there is another strategy you can use instead of taking the bank to court because they got more money than you, and that is to use what we call a land trust. A land trust is a grantor trust, just like a living trust. They're used to seeing them. It's not a problem. They're not going to get excited by you putting a property into a trust. But this particular trust, called a land trust, allows you to actually take title to the property in the name of the trust, but then the beneficiary of the trust is assigned then to the limited partnership or LLC. That's a private document and the banks don't even know about it. So sometimes if we really find it's important to do asset protection and the bank might give you trouble over it, there is still a legal strategy that we can use and they don't even know about it and we do it anyway. So now one little comment. The loan, whether you put it in, the loan that you had on the property, because that loan was in place before you retitled the property, even after you retitled the property, that loan is still in place even within the limited partnership or the limited liability company. And that's why that you can let them know kind of what you did. So even if you put it in the name of the trust, they'll still see that. But if you don't believe what I'm telling you, just quit making your payments after you put that property inside of a living trust and watch how fast they take the property out. So the lien does follow itself into the property when it's been there before you retitle.